again. It turns out, inevitably, that there is some unfinished business regarding Professor Anne Twomey's Magna Carta video. In her introduction, Professor Twomey correctly said that Magna Carta 1215 was an agreement. It was, in fact, a treaty between the barons and King John, who were, if we accept the detractors' claims that John was under duress and at knife point, clearly in a state approaching war, if not actual war. A treaty, however, includes only those who are parties to it, automatically excluding any others. As Parliament was not even in existence until decades later, it clearly cannot be involved in amending that treaty's terms. The protagonists of parliamentary supremacy may assert their authority to revoke, amend, or otherwise change the terms until the cows come home, but their alleged authority is non-existent. It doesn't exist in nature, therefore it's an artificial contrivance of men's scheming. Professor Twomey seems almost gleeful in claiming that the rights granted to the barons applied only to freemen, not to bondmen or slaves. This raises two vital questions of principle. One, does anyone, no matter what their position in society, have the authority to either grant or revoke rights that exist in nature to anyone else? Are not all born with the same rights? Two, does it sit well with Professor Twomey that a constitutional principle should encompass the concept of different classes of people, especially those who are free and those who are slaves or not free? If Professor Twomey finds this extreme irregularity acceptable as a basis for a rule of law, of what value does that rule consist? Isn't any person, free or bonded, justified in rejecting such an abhorrent concept and morally obliged to do so? Professor Twomey strongly implies that Magna Carta was relevant only to medieval values and society. But is human nature any different now than it was then, or in any past age? If individual human rights exist in nature, how can we justify with an argument that they should change over time? I've dealt with the feeble claim that the Pope annulled Magna Carta 1215. Now let's turn to the equally ludicrous assertion that Parliament could simply claim the authority to chop this treaty, which was, as shown previously, binding in perpetuity on all monarchs and their administrations, into little pieces and dispense with the ones they didn't like. Professor Twomey decries those who use what she calls snippets of the Charter to claim exemptions from legislation. But wasn't Parliament doing exactly that in reverse, to frame the legislative web that currently claims to enmesh our community? From whence does Parliament claim this authority? Isn't Parliament just a nominative group of people? They may have been voted into office, but from whence comes the authority for an individual with no right to coerce another to somehow transfer this non-existent authority to yet another party to be used to coercively enforce the edicts of a group onto the bodies of an even more remote group or individuals? It's an absurd concept that doesn't hold water logically or morally. Twomey seems perfectly happy to assert that because some people have been asserting this authority and enforcing it in contravention of natural law since time immemorial, that this is all okay. And why should anyone have the temerity to question it? Well, Professor, we do question it. We not only question it, but we also reject it as inhumane and immoral. It is a system where some people have assumed, usurped would be the proper word, that whatever they say will be the law, and woe betide anyone who calls it out for the evil that it is. If this is the case, what is to stop the government from passing any law it likes, including who is to live and who to die? Magna Carta stated that no one should be punished or distressed by the state in any way, unless it is by the judgment of their peers or the law of the land. We can argue whether the "or" in that case means either, or whether it simply is a means of reiteration of a concept, such as we might find in the comment, "The plaintiff is calling for the application of capital punishment or the death penalty, the death sentence." Who is to say which is the correct interpretation? Will Keat answered this with his quote from Emperor Conrad, which used the unequivocal word et or and. If the aim of justice is to avoid errors, is it not incumbent on the system to embrace the concept which affords the widest interpretation? This is consistent with the view that a jury must acquit if there is reasonable doubt about the accused's guilt. Why shouldn't the same principle apply to the entire concept of judicial administration? What makes the likes of Professor Twomey and her legalistic fraternity correct in insisting that it's a case of either or, and that their preferred choice of legislated law, where the concept of mens rea or the guilty mind, which is the job of the jury to determine, is relegated to virtual abolition, should take precedence over an individual's right to a trial by their peers? The job of the jury is to provide the final absolute safeguard against the tyranny of those in government, which history shows us inevitably leads to corruption and injustice. Twomey and her ilk like to toss around like confetti the word law, as if that sanitizes any infringement against an individual's natural rights that they may whimsically dream up. It does not. But people are awakening to the concept that it is justice, not law, which is lacking in today's society. Interestingly, this video of Professor Twomey has the second highest number of views in her series, the only one surpassing it being the topic of the government's legitimacy in its dealings regarding the so-called COVID pandemic. It appears, Professor, that the topic of government legitimacy and its relevance to natural law is resonating increasingly strongly with the common people. Professor Twomey and her legalistic friends are adept at quoting reams of legislation, legal precedents, and the pronouncements of learned jurists as sources of their authority, and dismissing those without strings of letters after their name as irrelevant. They make the fatal error of dismissing the arguments of those with morality and principle on their side as of no account. But if their own arguments are supported only by the application of force or violence, not by the principles of natural law, they have even less validity than those of the supporters of equal individual rights. Proponents of Magna Carta 1215's validity and the validity of the trial by jury system can also quote numerous sources for their opinions as to what is true law. I refer, as previously, to the excellent work of Ken Dewdney in Democracy Defined, the Manifesto. Links in the comment box. This is only one example. In summary, both sides of the argument often quote the same sources supporting their views. So where does that leave us? It leaves us having to rely on principle, does it not? And which is the superior principle? Is it the principle of de facto dominance by force, or the principle of individual rights and equality before the law, which exists in everyone's view as natural and just? The legislator crowd knows this and reasons correctly that it is well beyond the capacity or desire of those desiring a peaceful existence, content with simply controlling their own lives, to become involved in such laborious contests about opinions. This is where Professor Twomey and those who enjoy lording it over everyone else with their false claims of legitimacy due to their alleged upholding of the law currently have the whip hand. But objectively, the current system, which these people call law, is a systematic violation of individual rights, and we are all under instruction, as per Article 61, to dissent and resist until it is replaced with lawful justice. The important fact to remember is that legislation is not law, a false equivalence. Law is that which exists in nature. The truth is that asserting because something is the way it is and has been so for a long time does not make it correct. Unless the legislature's power is strongly curtailed, any society will eventually find itself in Australia's current situation, which is a nation of serfs, bullied and harassed by a small coterie of elites, backed up with an army of despicable order followers who daily commit sacrilege regarding their oaths of office. And until we get 10 to 20% of the population understanding this and standing up for their rights as protected under Magna Carta, that's the way it's going to stay. Of course, it won't always stay that way. Unless enough individuals stand, it will get progressively worse. That is a certainty. We can perhaps have an easier life for a time by just going along with the illegitimacy and the criminality of our government. But our children will not. Think about it, then act. Thank you for watching.